5490. Donna Johanson and Nick Casavelli and Nicolina Castelli. Who do we have on the line for the plaintiff?
Good morning, Your Honor. Bryan Eastin on behalf of the plaintiffs in this matter.
Thank you. And do we have a representative of the defendant? Do we have one of the defendants?
Nick Casavelli here, Judge.
All right, very good. Excellent. Thank you. All right, I set this matter for a status conference because we have a trial, a lengthy trial that is set to begin on March 20th. We have a final trial management conference for that trial coming up, I believe, next week. So given what you all have filed and the issues relating to trial preparations, I wanted to make sure that those trial dates were still viable and to see what, if anything, we needed to do to make sure this is on track. Mr. Eastin.
Thank you, Your Honor. From the plaintiff's perspective, those dates are still viable. We're ready and willing to proceed. We did get filed our motions in limine on Friday, and yesterday we filed our joint pretrial, our unilateral pretrial, along with proposed jury instructions, proposed voir dire questioning, proposed time for questioning of witnesses, all in accordance with the court's July 26, 2021 minute entry. We admittedly were late. We filed the request for clarification on the due date for all those items just because the defendants were not willing to cooperate in a joint pretrial and threatened sanctions towards us in case we filed anything, whether it's the motions in limine or the pretrial. So we needed to file that in order to get the court's direction because they were making an argument that the case should not proceed forward based on the fact that there was a pending appeal. And so we didn't want to be in violation of the stay or subject to any kind of sanctions motion. So we do now have everything up to speed in furtherance of your minute entry that was, I believe, entered last Monday, which said to get things filed immediately. So we restyled our documents and got them filed as quickly as we could.
And does that mean, Mr. Eastin, from your perspective, that there's no further discovery, that discovery is concluded and everything's ready otherwise for trial?
Yes, Your Honor. The court ordered discovery closed, I believe, last March, something around there. So I don't believe there's any further discovery that could take place or should take place. And we're prepared to move forward with our trial.
Okay. And then just for my benefit, tell me what the parties did to try to resolve the case. Was there a formal settlement conference, ADR? What was on that issue?
We engaged in ADR some time ago, Your Honor. I think it was probably within the first 2 years of the case after some initial discovery had taken place. The ADR was completely unsuccessful, and there have been no settlement discussions since then. And there were efforts even before we filed to try to resolve the matter with Mr. and Mrs. Casavelli, but they did not see things the same way the plaintiffs did, so they refused all such overtures.
All right, thank you. All right, Mr. Casavelli.
Yes.
Same question for you. Is the March 20th 8-day trial still viable from where you sit?
No. There's pending motions for depositions for Garpdon. All the claims by the plaintiffs stem from Garpdon LLC. The plaintiffs are members of. There is a false claim of assignment of interest to themselves to trying to protect the LLC, which is not legal by law. We already know this. We've talked to the Corporation Commission numerous times, and they've explained that by the Johansons assigning interest to themselves, they're essentially closing the LLC. So it's not possible. We need a deposition from Donna Johanson, which was removed from us last October, okay, by Mr. Eastin's scheming to say that we failed to appear at a virtual deposition, and a virtual deposition was never noticed. We're not ready for trial until we get her deposition, or at least Garpdon's deposition. The trial that's set is not viable because the discovery is not closed. I've never heard of it, and I can't find any rule anywhere, and no one can reference a rule that says discovery can be closed. My understanding is that any information that proceeds to commit to justice in any lawsuit is to be admitted and to go forward on it, not to close you out and refuse you the right to any evidence that can prove your innocence or guilt for this matter. And as for this issue in not working with the plaintiff's counsel, January 24th, I called Provident Law asking Mr. Eastin 3 times. What we received in return was if he did not return the call, first and foremost, what we received in return was a notice from our internet provider that we have been calling and harassing him, and our internet was shut off. So when he submits his 6 motions saying he conferred in good faith that he tried to call, he did not call. He didn't send an email. We only received the emails yesterday of the motion of memory and everything else was filed. This was the first day the internet was turned back on. These are the things we've been dealing with Mr. Eastin for 5 years. So trial is not viable. He has misrepresented the court. We didn't say we wasn't willing to work with him. We actually called to discuss this issue on January 24th. He would not return the call. Now he misinforms the court of these things. He says we threatened him with sanctions. This court, you, told him to seek information from the higher court about the stay. He did not. We did. We talked to the appellate court. We talked to the Arizona Supreme Court, and we talked to the United States Supreme Court. The mandate has not been returned, as Judge Duncan stated, that she would do nothing, and this court would do nothing until the mandate was returned. There's an issue of being deemed a vexatious defendant. We find offense to that because how do you deem us vexatious when this has not concluded to say that it went adverse to us, that we did anything wrong? Yet here this is pending. There is no final order on the vexatious defendant because no mandate has been returned from the appellate court. The appellate court stated just yesterday to file a courtesy copy of the petition for rehearing. We did. We sent a copy to your office and everyone. The issue is that they have not returned the mandate. They were very clear about that. They were very clear that the Superior Court does not have jurisdiction to move forward. Yet, Mr. Eastin misrepresents to the court again, as he has for 5 years, to push this court into violating our due process rights. And that's where we stand on that. We don't think the court has jurisdiction to handle anything. We do not think that the March 20th to the 31st court date is viable. Not at all.
Not when you have 3 different courts telling us that there's no jurisdiction, no transmittal letter back to the Superior Court yet.
Exactly. Now, depositions. How is it that we're going to be pushed into a trial without ever obtaining Donna Johanson's deposition? It was wrong. It was wrongfully removed. Now, my understanding is the rules is no surprises, and we've been forward and upfront about everything and disclosed thousands of documents in this case. On the other hand, Mr. Eastin has not, other than tell the court that we've threatened him. We don't threaten him. We follow the rules. If there's a problem with following the rules, then I'd like the court to explain to me how we're violating the rules. Even the rules of society and the laws. I don't see how we're doing it, and yet whenever we ask this for clarification, we get denied clarification. Just as you denied him clarification on the orders and told him to seek information from the higher courts, he did not. We asked the courts if he had called. No, he doesn't want clarification. He wants to push us into a trial, rule out every bit of information that proves that he filed this fraudulently against us, that he got his clients into a criminal investigation because of what he did prior to filing this. And the only reason he filed this litigation against us, Casavellis, is to get his clients out of a criminal investigation that he wasn't retained for. He did this because of his prior actions to this litigation. And he has ruined our reputation by all the lies he has made in us. And now he wants public records kept out that has been submitted in other courts. He wants videos kept out. He wants depositions kept out. He wants to keep us from having depositions. And the court has been willing to do this for him for 5 years. We have been fighting this for 5 years just to get fair and equal treatment in the court system, and we don't feel we get it.
Just one thing that I would like to say is that when it came to the virtual deposition for Donna that Judge Duncan set up without any alternative date, our court reporter was not available on that day. Mr. Eastin knew this. Any other court reporters required 10 days notice, which there wasn't enough time for that. Mr. Eastin had his client, Donna, come to his office and then email to Judge Duncan to get her to call. She did, because he said there was a deposition in place and that we were not being cooperative. That wasn't the case. We had a doctor's appointment. We had to leave because that virtual hearing wasn't set up with a court reporter.
And then we give us 11-minute notice of this. We made that hearing just to be a system set up in place where Mr. Eastin petitions the court for the court to waive our right to a deposition, which is wrong. Which a prior judge, Judge Bruce Cohen, in 2019 said we have a right to her deposition, and he will not let that take place. And honestly, there's no way that I don't think a jury in the world is going to listen to him if we don't get her deposition and know what's going on in court. We're walking in there blind to an ambush.
How can anyone believe what he says when he lied? I'm saying it. He lied to Judge Duncan saying there was a deposition in place when there wasn't. He knew there wasn't.
Okay, let me ask some questions. So, as for the I think you said the deposition was to occur in October. What, if anything, did you do after that to take that deposition? Well, we noticed Garpdon, because Donna Johanson and Gary Johanson are members of Garpdon LLC. We noticed Garpdon to the deposition. Mr. Eastin then filed a protective order for Garpdon, who's not a litigant party, not a party to this right now, and he doesn't represent them in this matter. He filed a protective order twice to stop the deposition because he pulled the play that we didn't show at a virtual deposition. He filed a motion to waive our right to Donna's deposition. Judge Duncan granted that right. Okay. We couldn't do anything about it. We asked her to change her mind on it. She did not. Okay. We've asked for the deposition again. Now there's 2 pending motions. We urged for protective orders to stop Garpdon from giving deposition.
He doesn't represent Garpdon or the subpoenaed parties.
Here's the biggest issue, Judge, is that I and myself and my wife worked for Garpdon LLC for 25 months prior to here. These allegations that Bryan Eastin has brought and the plaintiffs have brought are directly from Garpdon LLC. They should be a party to this. That LLC should be, but they're not. He has stopped every means of adding Garpdon or getting depositions from Garpdon or Donna Johanson. We managed to obtain Gary Johanson's deposition, which is one of the things that he wants that motion limiting out, is the video where he stands up and almost takes a swing at me. He interferes when I'm questioning on a line of questions he doesn't want, which is the incidents that took prior to closing Johansson's sister-in-law's irrevocable asset trust.
He answered for the deponent, all sorts of things. Over 400 objections that he says were just to put it on the record. And according to the rules, you're not allowed to do that.
When we inform the court, we get sanctioned. For informing the court of his wrongdoing, we get sanctioned. We object to sanctions. We get sanctioned again.
The appellate court of Arizona removed those minor sanctions.
Now, I would ask this of the court. If the court can explain to me how a defendant can be vexatious, is there a possibility to get that explanation? Because I don't understand it.
We don't have any prior lawsuits. We don't have any anything on the record from any of the judges in this case that said we've done anything vexatious. And
then, if Judge, if you could answer that, please. Then can you tell me, how does a minister be vexatious? Because Eastin knows this. Mr. Eastin knows we were ministers prior to this. He tried to think we're easy marks. we just lay down and take it. This has nothing to do with the issues. The issues that he does not want is the motivation for bringing this lawsuit against us. And that is clear, that he does not want that in because it shows his criminal behavior, because it could be nothing more. At least it's unlawful.
And Judge, back in 2017, September, we asked Bryan Eastin flat out, what are the Johansons alleging? He said he couldn't tell us because it was attorney-client privilege, but then he went ahead and proceeded to tell us everything that was in the complaint. So we asked him about what are they saying about the house? He goes, well, in his words, there's nothing in there that says you did anything wrong in terms of fiduciary duty or selling the house. And that's provable.
And now he wants blanket motion.
He admitted that we didn't do what he's saying, but yet it's all in the complaint and it's all wrong.
He wishes the court to issue a blanket motion to wipe out massive amounts of information that would absolutely prove to the jury that he brought a frivolous lawsuit against us and has been litigating this for 5 years, and he has petitioned the court to listen to him instead of us. We've been silent. Yes. We've been silent for 5 years. We haven't fought much in the state court because we didn't want to draw attention to it. We are now going to fight all that we can. We have tried to protect the rights and do the right thing. Okay, maybe it wasn't in the proper order. Maybe it still isn't. But the fact of it is we try to obey the law. We try to respect the court. The court has shown us no respect when we offer the forged documents that Bryan Eastin once kept out from in front of a jury. When we offer those to the courts and they sanction us in the amount of $37,000 for giving proof to the court that he committed forgery and fraud.
After being told, get it to the court.
He wants recordings of the Johansons admitting that Bryan Eastin altered and made subpoenas and got bank records before the litigation was even filed. This is the stuff he doesn't want before the jury, and this is what the court has been willing to keep from a jury. The truth be said, there is absolutely no way that this can get before a jury that's not going to cause some kind of question of his wrongdoing and the Johansons' wrongdoing. Because everything leads to what he's trying to hide.
If the court would just listen to the evidence we have, which was gained lawfully, they would unequivocally see the proof is there.
Okay, and thank you. And you're referencing motions to limine that haven't been ruled on. So, those are still up in the air. We'll resolve those in due course. Thank you. So Mr. Eastin, I'm curious about the deposition from October. Can you give me your view on how that came about and what that leads for today?
Sure, Your Honor. There have been several attempts by the defendants to take Ms. Johansson's deposition.
8 of them, Your Honor.
And we came to the end of a deadline that the court had set to conclude discovery, and they attempted to take Ms. Johansson's deposition after that deadline, so I filed a protective order. The court granted some additional time to take her deposition. They still didn't take it. Then there was another deposition notice out that we went to appear at, and there were disputes there at that deposition that we took issue with. So we left the deposition, filed for a protective order, explained to the court what was going on. The court set another time for a deposition for Ms. Johansson to be taken virtually, and that's the September deposition I think that they're referring to. October. The court established that date on its own, and I had Ms. Johansson here in the office ready for that virtual deposition, and it never took place. So we contacted the judge, and the judge then allowed yet still another opportunity for them to take the deposition, but warned them that.
Excuse me, she did not. Nowhere on the record is there a secondary chance to take a deposition after you pulled the alleged virtual deposition that we failed to appear, that we did not even notice, and that the court reporter wasn't allowed for. Now, you're misleading the court again, Mr. Eastin.
It's my recollection. It's my recollection there was still another opportunity, and the judge said it would be the last opportunity to take her deposition, and that did not occur. That's my recollection. I could be wrong on that, Your Honor, but the record is what it is. I don't have the ability where I'm sitting at my conference room to pull up the pleadings or the minute entry on that.
So this would have been October of 22?
I am not sure.
Last year. Yes.
I think it was. That's my recollection. So every opportunity the court gave for one reason or another, on the last two most recent opportunities, it's my recollection that the defendants didn't follow through with what the court ordered. And so the court ordered that they'd had their opportunity, discovery was closed, and there would be nothing further to allow her deposition to be taken.
Would you like to explain your behavior at the deposition that happened on December 16th, Mr. Eastin? It is on video.
Well, yeah, I don't want to get too far into the weeds here. I appreciate all of the.
They have a rebuttal to this because he clearly just lied to you. He did appear for a deposition, present his client for an in-person deposition on December 16th, I believe it was 2021. The issue with that is that he demanded placement of the camera as additional method. The official court reporter was the official method of recordation. Additional method was camera. He demanded that we position the camera that it catches everyone on it. Judge Daniel Flores said that it's never been that way, in her understanding that it's always been on the deponent, which is the way it was set up to be. Anyway, the official court reporter was there to take the deposition. He read not only Rule 30 of the Federal Rules of Civil Procedure, he read Rule 30 of the Arizona Rules of Civil Procedure, and he refused. He refused to allow the deposition, and he walked out after 51 minutes of arguing with us.
Even with the court reporter asking him to please comply on a notice deposition, he refused.
We did attempt to call Judge Flores. She was not in for the day. So when the court reporter asked him what he wanted to do, he says, I want to wait for the judge. And she was not in.
He had just been told the judge was out for the day.
Okay,
there's so issues that he always stopped.
Gotcha. Okay, so Mr. Casavelli, and by the way, your wife Nicolina, is it Castelli or Casavelli?
Castelli's her maiden name.
Okay, so should I call her Miss Casavelli?
She doesn't mind.
I don't care. I mean,
I just want to make sure ma'am, I just want to make sure we're calling you by your correct name. I don't want to disrespect you by calling you something that's not your name. So what would you like us to address?
I have a question for you.
Okay.
You said about the scheduling order. Back in, it was, I don't remember the exact date. It's been 5 years.
August 15th, 2019.
That's right. Mr. Eastin asked the court to suspend all discovery deadlines, including dispositive.
Until an amended scheduling order was submitted by the court. And
an amended scheduling order has not been ever reintroduced into this litigation since then. Mr. Eastin suspended it, but it's never been amended to bring everything back. So the scheduling order is moot, kind of. And
has constantly used that against us, saying that there is a scheduling order in place when there never has been.
No, because it was never amended after he had it suspended.
Judge Cohen granted that order on August 18th of 2019, or 2018, I think. 2018, I think it was. And there's never been an amended scheduling order. And it's just been make up the rules as we go along. So it's been kind of hard to keep up with this. And he likes to play his little legal games here, and it's at our expense.
Mr. Eastin even argued that Judge Cohen didn't take away the dispositive motions, but when you look at his minute entry order, it absolutely includes all dispositives, and no scheduling order has ever been amended after it was taken away.
Okay.
So we have issues when it comes to this deposition.
But right now, the issue is jurisdiction. The appellate court told us that there's no transmittal.
Right now, our issue is deposition.
Yeah.
Okay. We know that Ms. Johanson will refute everything that Mr. Eastin is claiming, and might as well call it Mr. Eastin's complaint, because the Johansons have already stated they wanted this to be gone back in 2018. There was, you asked about settlement conference. There was a settlement conference. Mr. Eastin's conditions for settlement was basically concede, say you're wrong, pay them $750,000.
And our attorney at the time said, no, that's not a settlement. That's you getting everything you want. So it didn't happen.
Okay.
So the arbitrator did propose a settlement. Now, I know we're not supposed to be mentioning this, but why not? He proposed $85,000.
Yeah. Okay. I don't. It's not something we should get into. Because I'm your judge for and potentially the trier of fact on issues. So it's inadmissible in court the settlement discussions, because we want to keep those confidential as to you and Mr. Eastin and his client, so that you'll have free and frank discussions. But that we're getting way into the weeds and way off track here on what I'm trying to do. So Mr. Casavelli, you are seeking, what I hear you saying is you are seeking a continuance on the March 2023 8-day jury trial because you believe you need to take Ms. Johanson's deposition.
We're not ready.
We have a right to take her deposition. We're being denied that.
The tier that he put us on says we have 30 hours of deposition allowed to us, and we haven't done that.
Break it down. We received 4 hours of deposition. He's gotten 8. Okay, that's not even fair. We deserve at least to get Donna Johansson's deposition, which he has refused. 8 official notices. Communication for, 40, 50 emails back and forth attempting to get this set. He refuses. He refuses because he don't want the information coming out.
Okay.
But he knows he will do.
Yeah, I'm just trying to.
He's never offered any settlement since the ADR. He's never mentioned it.
Right now it's about a deposition.
Yes.
We are not ready for trial until we get her deposition.
Okay. So I'm trying to focus us on what what you're requesting and where things stand. And what I hear you asking for is you're asking for a continuance of the 8-day trial in March so that you can conduct a deposition of the plaintiff.
Yes.
Okay. And Mr. Eastin, I take it you oppose that. And I do want to go back and review the scheduling orders, and we do have these various stays of events, either the appeal or otherwise, that have interrupted that schedule. But here we are. We have this case was filed in 2017, and it needs to get to trial. But we have to make sure we're doing this in the interest of justice. So that's the balance I'm focused on. But Mr. Eastin, your view.
Yes, Your Honor, we wish to push forward. This is our third firm trial setting. The previous 2 trial settings were vacated also because of the defendants. They claimed that
not true, Your Honor. Not true.
One was taken away because of Judge Cohen's scheduling.
All right, no, I will give you time to respond, Mr. and Mrs. Casavelli. I need to hear one at a time. That's the way this has got to work. Mr. Eastin.
Yeah, I believe the first trial setting was vacated because they claimed they had a work conflict, so the court gave them a later date. That later date had to be vacated because the defendants had taken an appeal up that caused a stay on the proceedings below. The appeal was improper because they were appealing an unsigned minute entry, so it's not an appealable order, but they used it nonetheless to cause the second trial setting to be lost. And now they're doing the same thing again, Your Honor. They appealed this vexatious litigant issue all the way up to the U.S. Supreme Court, trying to cause this trial to not occur either. The U.S. Supreme Court has denied their petition for certiorari, and it's true the mandate hasn't issued yet, but the vexatious litigant determination it's not an issue that's going to be tried at trial. That's just a procedural mechanism to try and control what's going on within the case procedurally. So there's not going to be not going to be any kind of submission to the jury for any kind of issue to declare them vexatious litigants. That was just for the court because they filed so many different sanction motions and kept doing repetitive filings. It was getting to the point where we needed to have some control. They haven't been prejudiced by that because they've managed to keep that issue going up on appeal for approximately a year to a year and a half now, and the vexatious litigant determination has never been enforced in this case. So there's nothing prejudicing them from that perspective. In regard to the deposition, they try to minimize what occurred in terms of saying that it was only the placement of the cameras. True, that's an issue I brought up, but the primary issue, Your Honor, was I asked them at the outset of the deposition if they were going to allow me to follow up their questioning of my client with my additional follow-up questions, basically a cross-exam of my client based on whatever questions they asked. And they said flatly that they were not going to allow that they were going to turn off the cameras and walk out once their question was over. So I explained that to the court, and the court agreed with me that was improper and indicated that. And we'd actually requested that because of how Mr. Johanson's deposition went. We asked the court for the deposition to be conducted in the courthouse because we were fearful for the conduct of how Mr. Casavelli carried himself. So that has a long storied history on it. The judge agreed with that, and then because of the use of virtual technology during COVID, we agreed the court set it up instead of coming to the courthouse because the Casavellis again objected to that on the basis of COVID concerns. The court granted them the right to do a virtual deposition, which fell through because they said they couldn't get they're claiming here today that they couldn't get their videographer there or the person to set up the deal, but they could have gone somewhere else and got that set up. So the court agreed with that, set up one more opportunity, my recollection, and they didn't fulfill that either.
What was the date, Mr. Eastin?
I hope I've answered your question, Judge. If I didn't, please repose it, and I'll try to be more direct.
Okay, and so for all those, hold on. So, Mr. Eastin, for all those reasons, you oppose continuing the trial to give the Casavellis an opportunity to depose your client?
I do, Your Honor. And my clients need to move forward on this. They're elderly. Mr. Johansson's actually passed away during the course of this litigation, coming up on 2 years ago.
No, he hasn't. That's a lie, Your Honor. He is alive. He lives a half a mile away from me. And this is a lie I've been dealing with now for 3 years, almost 4 years. Mr. Johansson is alive. He pulled this to get Mr. Johansson. Mr. Johansson didn't want to testify in this case. I seen him last week and talked with the man. He's alive and well.
Your Honor,
this is the theme that this man has been pulling right here. And we are tired of sitting here and letting him lie to you and disrespect us and take these personal attacks that he's always done. And this is what he does. And with 5 years in the court's delay. So we'll let him finish now. I'm sorry.
All right. So, Mr. Eastin, you're saying your client's deceased, and we have Mr. Casavelli saying he saw him last week. That's a new one for me.
Yeah, Your Honor, I've got an open probate for Mr. Johansson's estate. I have a certified death certificate. I attended his funeral, Your Honor.
And we have video of him 2 years after his death, Your Honor.
Yeah, they claim to have that, Your Honor, but that's not true. They have video of some elderly person, but it's not Mr. Johansson. So we stand in the position that he's deceased. My client will testify to that. She was married to him for close to, I think, 50 years or something like that. So.
Okay. All right. So,
Your Honor, the fact of it is that it's Mr. Johansson, and we was denied a public jury act because of a false will that Mr. Eastin manufactured involving an attorney named Kevin Kinghorn out of Tucson. which is where the Johanson apparently had a legal separation, because Mr. Johanson, if he's dead, why did they amend the articles of Garpdon LLC, leaving Mr. Johanson on as a member if he's deceased? They left him on there. There's issues here that and it comes for this deposition that for Mr. Johanson. Mr. Eastin recorded the deposition on his phone, never noticed us. Mr. Eastin stood up to take a swing at me because he didn't like the question about where $120,000 went. Okay. Mr. Eastin is the one who interrupted 400 times. Mr. Eastin restated questions. Mr. Eastin is abusing the deposition. And when he was told simply to shut up, he wanted to get violent. And this was 3 hours and 25 minutes into the deposition, and we did not deny him to re-question or to fault question or to whatever the technical term is after we questioned Mr. Johanson or Mr. Johanson, and he's telling the court that we denied him flat out. We said if there's time, because the rules say we're only allowed to do 4 hours deposition. If there's time, we didn't know how many questions we'd have or how long it would take him to answer. We didn't deny him anything, but yet we're being denied.
Okay. All right. So we're going to conclude. I've got the update that I need. And Mr. Casavelli, I have your motion to continue the 8-day trial so that you have the opportunity to depose Ms. Johanson. That's your request. And I hear Mr. Easton's opposition to that request and his request that we reaffirm the trial date. I want to go back and read this. Your docket is 11 pages long, which is quite long. Mm-hmm. So I do need to scan through this so that I can get a better understanding of where we've been and where we are. It is a 2017 case that needs to get to trial. But I understand in the interest of justice, Mr. Casavelli, you're asking for the deposition of the plaintiff in advance of that trial. So let me.
I don't want to give him anything that will cause us to go on appeal. So if it's not done right, he's going to file an appeal, and we're going to continue this forever. We want it to be done right. So, and we're looking forward to trial. By the way, we really super are. We're not going to try to put anything off, but we don't want to give them the ability to keep coming at us year after year after year under a different name, under a different company, or a different trust, or whatever. And this is exactly what he's doing. The conflict of interest that he represented us is the reason why he brought that lawsuit against us to get his clients out is the issue he wants suppressed. These are reasons that there shouldn't even be a trial. It can't keep this information coming out from in front of a jury. There's going to be a mistrial because there's just no way in the interest of justice to have a trial and have evidence submitted, which, by the way, we're not submitting any motions in limine because we want him to bring his information the way he wants to say it and present it, because it's all going to lead to the same thing that he wants out. Okay, just like the deposition he wants out. Just like he's saying it's our fault that we keep dragging this out. We're trying to do this to where this will end one way or another. And then 2 weeks after this, he don't turn around and file another lawsuit under a different name and doing the same thing, because this has cost us basically $400,000 now. And we're tired of fighting this because it seems to go nowhere. And he's the issue. This case would have been to trial within 18 months if Mr. Eastin had recused himself for conflict of interest.
If you
but he wouldn't do that, and he still won't.
You would understand it exactly, the conflict of interest that has been there since before he even filed. We still have a reply due on that one and another 2 motions there.
Which is, let's bring the question, where does those motions stand?
One last thing, Your Honor. If the Supreme Court does grant our motion for rehearing and we get forced into a trial before they have the oral argument or whatever, how are we supposed to go to trial when that is pending?
And he said that it doesn't affect trial. He is the one who has mentioned he's going to put it before the jury about us being deemed vexatious defendants. There is no final order that changes his not barely tapered restrictions, okay, and that we are to be constrained and set there, duct taped to a chair and be silly at his command, because that's what he's wanting us to do, not to have any response, any voice, any evidence, or any defense. We're not doing that. We're trying to at least make it fair and equal, and we've never said that the Johansson doesn't have a right for their day in court.
No, never said that.
Okay.
But the fact is, he don't want us to have our day in court.
And
we want it where it doesn't keep going.
You are still agent for Garpdon, which causes the conflict that is in the motion to disqualify. It explains it to the nth degree, Your Honor. If you just read that one, you would understand a lot more.
Okay, thank you. I do have some homework to do, and I have your motion to consider. Thank you all for your time, and we'll speak again for sure on February 16th to either do a final management conference or discuss other pending matters. Thank you all for your time this morning.
Your Honor, your question.
What was the motion you just referenced? You said you'll consider their motion. What motion are we talking about?
The oral motion to continue.
Oh, okay. Thank you, Your Honor. Appreciate that. Thank you.
Your Honor, do we file our replies to the pending motions?
Even though there's a stay?
What's the pending motion?
He has two motions for protective orders. There is a motion for disqualification of him for conflict of interest, and there is a motion for joinder of party, which would be adding Garpdon to this litigation, which is the rightful person who's claiming damage, the rightful entity claiming damage, not the Johansons. If you look up the assignment of interest and you understand LLC laws and business laws here in the state of Arizona, he's claiming that the Johansons assigned interest to themselves to bring this into personal capacity when it's not possible when the alleged damage
to answer, yeah, all right. To answer your question, if you have a reply pending that you've held off because you believe the case was stayed, you should file that reply.
Okay.
And Your Honor, it may help you to look at the March 31st, 2022 minute entry, which talks about the motions that they're referring to.
All right. Thank you.
You bet.
You filed when there was a stay on, Mr. Eastin.
All right. We're adjourned.